Many times clients contact my office about removing an old restraining order in New Jersey. There are several ways to do this. Number one is the plaintiff voluntarily dismisses the restraining order. The problem with this option is the defendant cannot contact the plaintiff to see if they would be willing to dismiss. That would be a violation of the restraining order, and you could be arrested and charged criminally with contempt of court. However, you can hire an attorney to reach out to the plaintiff to see if they would be willing to dismiss the case. Most of these cases, a lot of time has passed, years and years. People have moved on with their lives. Someone moved across the country, has a family, remarried, kids, things of that nature. We can reach out to the plaintiff and see if they would dismiss the case. If they are unwilling to dismiss the case or we can't reach them, a second option is what's called a Carfagno motion. It is a motion to vacate or dismiss the restraining order. The case is Carfagno v. Carfagno, and those detail the factors that the judge will consider when determining whether or not a final restraining order should be removed. Because there's a reason New Jersey makes these restraining orders permanent. They typically want them to stay in place forever. So if we're going to try to overcome that, we need to prove to the court that you are an eligible candidate for that to happen. Some of the factors the judge will consider based on the Carfagno case include the following. Most importantly, how much time has passed since the issuance of the order? I usually recommend waiting at least 5 years. Longer would be better, but it's all going to be based on the facts and circumstances of your particular case. Do you and the plaintiff have any ties, any reason to stay in contact? For example, do you have a child together? Are your children grown? Are they little? Do you still have to deal with each other on a regular basis? If so, they're less likely to grant the restraining order. They want no contact and no ties between the parties so that everyone can move forward with their lives. They're also going to look at, has there ever been a violation of the order? It's best if there have never been any violations. If there has been a violation and it was dismissed, proven to be unfounded, that would be all right also. Also, the judge will ask, do you have any domestic violence orders from other people, other women? That's another factor under Carfagno. If multiple people have filed restraining orders against you, that can be damaging to your ability to remove. Have you ever received any counseling? If you received domestic violence counseling ordered by the court after the issuance of your final order, that will be helpful. If you did it voluntarily, that would also be helpful. So these are all of the factors the judge will consider when determining whether or not to grant this Carfagno motion. Do the parties live across the country? Have you clearly moved on with your life? Is this your ex-wife and now you've been married for 15 years, you have 3 kids and you live in California? Things like that. Very persuasive to show the court that this order is no longer needed to protect the plaintiff and should be removed. To file a motion, we draft a certification detailing everything about your life, what's been going on, addressing all of these factors in the Carfagno case. We file the motion with the court. Once the motion is filed, the plaintiff has to get notice that you're filing. Okay, they are supposed to keep a current address on file with the court, telling them where they live so that we can serve them with this paperwork. Once the plaintiff is served, another important factor in Carfagno is, does the plaintiff object to the removal of the order? It's not a deal-breaking factor though. I have had cases where it's been 30 years, people have moved on with their lives, no violations, the person had counseling, and the plaintiff still objects. The judge found that to be unreasonable objection and dismissed the restraining order over the objection. Once the plaintiff is served with the paperwork, it will be scheduled for a hearing. The judge will ask questions. The plaintiff can be placed on the record to testify if they want. They can submit something in writing, just a letter with their opposition, or if they consent to the dismissal. If the plaintiff doesn't object, many times, based on our motion papers and all of our persuasive arguments, based on the Carfagno factors, they might grant the motion on the papers. There might not even be a hearing. But if the plaintiff objects, if they want to be heard, the judge may take testimony from the defendant so that all of the factors can be placed on the record, and then the judge will issue a decision. If the restraining order is dismissed, it goes away, your firearms rights can be restored, and the regulations and restrictions on your ability to travel or contact this person are no longer in place. If you need assistance filing a motion to remove a restraining order in New Jersey, contact my office. We've handled a number of these matters and we'd be happy to assist you.